At the invitation of the government, I visited Montenegro from 19 to 26 September. During my visit, I met with high-ranking state officials as well as judges, prosecutors, lawyers, and a wide range of civil society and non-government representatives. I wish to express my gratitude to the government of Montenegro for its support in the preparation of the visit. These are my preliminary observations and recommendations on the independence of the judiciary in Montenegro. My final report will be presented to the Human Rights Council in June 2024. I've seen much to commend in my time in Montenegro. In the past several years, Montenegro has embarked on a far-reaching reform of the judicial system. Its constitution guarantees the independence of the judiciary and creates a system of institutional bodies to safeguard the separation of powers. Legislation spells out detailed rules and procedures for the selection and appointment of judges and prosecutors, as well as other essential aspects of the judicial and prosecutorial career. More recent legislative amendments have been drafted based on consultation with judges, prosecutors, and others. I've also seen evidence of good practice. Montenegro is a place where energetic political debate flourishes, and I've been particularly struck by the country's dynamic and committed civil society sector. These NGOs work with extraordinary dedication to protect and promote fundamental human rights. Their continued involvement in law reform should be welcomed. Within the formal justice system, the Special Prosecutor's Office has taken a proactive approach and demonstrated independence in its willingness to consider evidence against all persons at all levels of the social and political hierarchy in Montenegro. I also note that the protector of human rights and freedoms enjoys widespread trust and respect in Montenegro. Over the past week, many interlocutors have told me their experience of good and fair judges and prosecutors who are doing everything they can to deliver truly independent and impartial justice. But these professionals risk becoming discouraged and disheartened by a system which is alleged to be impacted by corruption and nepotism, and which fails properly to evaluate, recognize, and reward their hard work. Meanwhile, ordinary people often find themselves excluded, let down, or unprotected by the same system. Turning to the imperative of judicial independence, it is the duty of all government and other institutions to respect and observe the independence of the judiciary and the prosecution service. The establishment of the judicial and prosecutorial councils was an important step for insulating the judiciary and the prosecution service from undue political influence. However, in accordance with international standards, these councils should include among their members a majority of judges and prosecutors elected by their peers. They may also include lay members, but their selection and appointment should preferably be entrusted to a non-political body. I repeatedly heard concerns that the inclusion of practicing defense lawyers on the prosecutorial council gives the appearance of a conflict of interest, as well as presenting a risk of actual conflict. Solutions should be proposed, such as inclusion of legally trained but non-practicing lawyers or academics. Many actors reported that the inclusion of an eminent lawyer proposed by civil society on the prosecutorial council has improved transparency and public trust in the council. Parties should consider whether a similar practice with regard to the judicial council could have the same positive impact. The Constitution provides that the Minister of Justice shall be a member of the Judicial Council, although the minister is precluded from voting in disciplinary proceedings. This is an important safeguard against political interference. However, I note the potential for decisions about other aspects of the judicial career, including on the transfer and promotion of judges, to have a comparable effect to disciplinary actions. I advise that this risk of so-called disguised sanctions should be taken into account in rules regarding the decisions on which the Minister of Justice is permitted to take part. Decisions on the appointment of judges and prosecutors should be based solely on merit, having regard to the qualifications, skills, and capacities of the candidates, as well as their integrity, independence, and impartiality. While it is appropriate for the legislative branch to be involved in the appointment of apex judges and prosecutors, in practice, political non-action has led to multiple vacuums in key institutions. The Parliament has failed on multiple occasions to elect the 7th member of the Constitutional Court, the Supreme State Prosecutor, and new lay members of the Judicial Council. As a result, strategic leadership in these institutions is lacking, and planning and action for reform of the system is not possible. Members of Parliament must put the interests of their country above politics and ensure that these appointments take place without further delay. The independence of the judiciary and separation of powers requires that the judiciary and the prosecution service are provided with adequate resources. However, almost all the judges and prosecutors I spoke to were clear that their work is significantly underfunded. Buildings are old, too small, and in a poor state of repair. Offices are crowded, and it is difficult for prosecutors to conduct interviews out of earshot of colleagues. During my visits to courts, I was shocked to see and hear about the inadequate facilities for storage of archives and evidence, including firearms and drugs. Additionally, privacy and confidentiality issues arise from the failure to ensure that archives are stored suitably away from public view. I welcome the government's plans for new court buildings and hope that those plans are translated into action. Judges and prosecutors, in particular those dealing with corruption, organized crime, and politically sensitive cases, face significant security risks that do not appear to be taken sufficiently into account by national authorities. In view of these deficiencies, I consider that additional resources should be provided, and that decisions on the allocation of funds to courts and prosecution services must be taken with the strictest respect for the principle of judicial and prosecutorial independence. The independence of the judiciary and the prosecution service also depend on the term of office of judges and prosecutors and their conditions of service. Both judges and prosecutors told me that their salaries were not sufficient to provide for a respectable and decent quality of life. Work-related rights of judges, including their retirement age and the right to an adequate salary, should be clearly regulated by a separate law on the judiciary. Public attacks on the independence and impartiality of the judiciary appear to be common. At times, politicians and media outlets put individual judges or prosecutors under the spotlight in an apparent attempt to influence their decision-making toward one desired result. This is not acceptable in a democratic society under the rule of law. The recent and well-publicized discovery of a tunnel into the basement evidence storage area of the High Court in Podgorica is emblematic of the issues I've already discussed. It provides evidence of inadequate security, dramatically inadequate infrastructure, and poor court design, and the high risk of exposure of the justice system to interference by outside actors. The reaction to this news demonstrates the pervasive tendency by political actors to engage in public commentary on the conduct of judges and prosecutors and to take credit for prosecutorial actions. Turning to the matter of integrity, integrity is essential to the proper discharge of the judicial office. Judges must ensure that their conduct is above reproach to the view of a reasonable observer. In 2022 and 2023, Montenegro witnessed an unprecedented number of criminal cases concerning corruption, organized crime, and abuse of office, brought by the Special Prosecutor's Office against high-profile actors in multiple branches of the judiciary, including the former president of the Supreme Court, the former president of the Commercial Court, a former special prosecutor, and a former prosecutor of a basic court. The outcome of these cases is still pending and must be left to the proper operation of the judicial system. However, These events can have done little to affirm the faith of the people of Montenegro in the integrity of the judiciary. In these circumstances, it is vital that institutions which have been tasked with considering disciplinary allegations about judges and prosecutors are proactive, rigorous, and fair, and are seen by the public to be acting in this way. In my discussions with civil society actors and NGOs, I heard many reports of complaints made to the Judicial or Prosecutorial Council regarding serious lapses of conduct, all of which were reportedly received no response. All complaints deserve to be treated appropriately, considered carefully, and should receive a response whatever the outcome. In addition to requiring the judiciary to act with integrity, international standards mandate that judges and prosecutors carry out their duties impartially. With a population of about 630,000, many people in Montenegro are well known to each other. These special circumstances make it even more important that mechanisms are in place to ensure reports of actual or perceived bias are addressed in a way that helps to reinforce trust in the judicial system. But these are not the only factors relevant to increasing public trust. The people of Montenegro must also feel that their justice system delivers high-quality procedures and justifiable outcomes. Competence and diligence are prerequisites to the due performance of judicial office. Many people express concerns about the deep dysfunction of the judicial system and unjustifiably long delays in obtaining justice. I heard of the preliminary phase of some organized crime and domestic violence cases taking as long as 7 years. I was told of very large backlogs, and I heard that the statute of limitations had been permitted to expire in some cases. I understand that constitutional complaints can take between 4 and 5 years, putting their status as an effective remedy in question. These delays have multiple causes. The Constitutional Court was left without a decision-making quorum between September 2022 and February 2023. The unexpected and discriminatory early retirement of many female judges created a deficiency in judicial numbers. The failure to make appointments to key leadership positions has limited the capacity to take strategic decisions on the operations of the judiciary. And finally, we heard that there are regional disparities in human resources. Judges must be supplied with appropriate systems that facilitate the discharge of their duties. It is incumbent upon the state and the judicial and prosecutorial councils to investigate and endeavor to resolve these issues. Beyond these systematic concerns, judges have individual responsibilities for ensuring their competence and diligence. During my visit, concerns were expressed that many judicial decisions are not fully reasoned, nor are they based on proper application of all relevant national and international law. To ensure their competence and diligence, judges should undergo evaluation according to objective criteria, including whether they give fully reasoned decisions based on appropriate case law and precedent and relevant international conventions. Delays in the conduct of a case may be relevant if they've led to the expiry of the statute of limitations, particularly in view of the possibility that such action may be evidence of an intentional failure to progress certain cases. In addition to competence and diligence, ensuring equality of treatment of all before the courts is essential to the due performance of the judicial office. Judicial officers should be aware of and understand diversity in society and differences among various sources. They must avoid manifesting bias or prejudice toward any person or group, and they must carry out their duties with appropriate consideration for the dignity of all persons. During my visit, several judges and prosecutors advised me that there were few or no groups who faced obstacles to attending court or accessing justice in Montenegro. This is in direct contradiction to what I heard from members of civil society. It also suggests that judges are not taking steps to ensure that they are not carrying out their judicial duties with appropriate consideration for the differentiated needs of groups facing marginalization and discrimination. Turning to the role of lawyers in the functioning of the justice system, Governments must ensure lawyers can function without interference and intimidation. I heard about cases in which lawyers were harassed for doing their job, including lawyers becoming a target for objecting to delays or procedural errors. I also identified apparent violations of the principle that lawyers shall not be identified with their clients. Lawyers also spoke of threats and actual violence as a result of their work as lawyers. The Bar Association of Montenegro must actively monitor compliance with the Attorney's Code of Ethics and take steps to ensure its members treat all people with equality and dignity. Given the apparently very small number of lawyers coming from vulnerable and marginalized communities in Montenegro, the Bar Association should take positive steps to encourage youth from these communities to train as lawyers and to dismantle any obstacles that may make integration into the profession difficult for such community members. The role of lawyers in encouraging participation of marginalized groups in the justice system leads me to my final topic, the extent to which access to justice is available in Montenegro. The right to access justice is guaranteed in numerous treaties to which Montenegro is a party. However, advocates and survivors told me that the judicial system fails to ensure equal access to justice for all. Observations during my visit, as well as information provided by civil society organizations and judicial actors, illustrated the many obstacles lining the path to justice for individuals and communities. Problems with physical accessibility were readily apparent. Many courthouses and other legal buildings are inaccessible to users of wheelchairs, and there is little provision for persons with visual impairments. Furthermore, procedural adaptations are absent. Documents and court decisions are not available in Braille, and court-certified interpreters and translators are not available for the Romani language. Vulnerable and marginalized communities have systematically sought the help of the judicial system, but they have too often been met with delay or worse. As regards the equal rights of LGBT persons, I understand that hate crimes against persons based on their sexual orientation or gender identity have been rarely qualified as such. I learned that prosecutors and judges have failed to apply the law to effectively protect Roma and Egyptian girls from human trafficking. I heard that survivors of family or intimate partner violence experience systemic failures, lack of gender-sensitive support, and even disparagement by judges and prosecutors. The failure to recognize the seriousness and escalating nature of these crimes had tragic circumstances. I was informed of more than one case where women have been killed in circumstances where authorities were aware that they were regularly experiencing violence from their partners. The existence of such consistent and pervasive failures across the justice system speaks of the need for greater specialization in these complex and sensitive cases. Furthermore, the expertise and dedication of NGOs working in these sectors should be recognized and funded through the government budget for free legal aid. Lastly, the collection of disaggregated data must be improved to inform activities aimed at improving access to justice and reducing discrimination, and permit changes to be tracked over time. However, this change cannot be implemented until Montenegro has a robust system of digitalization in place. I've outlined many issues that I observed in multiple parts of the justice system. It may seem overwhelming. However, I submit that it is clear what Montenegro has to do, and that the country is capable of meeting the challenges ahead. I was repeatedly told by interlocutors from all parts of the judiciary, prosecution, and civil society that many of the laws and systems necessary to ensure independence, integrity, and quality justice services are now in place. However, implementation and the will to improve that implementation remains deficient. If Montenegro cannot or will not take appropriate steps to ensure the independent, impartial, and competent functioning of the entire judicial system, then a radical accountability measure may be considered. The issue of vetting was raised on multiple occasions. If this radical step is taken, the state must guarantee that vetting is independent, objective, temporary, and respects the right to a fair trial of all who are affected. The establishment and composition of vetting bodies must be set out in law. The membership and character of vetting bodies should be judicial and not political, and the vetting process should include an appeal tribunal in line with human rights standards. It is for the people of Montenegro to decide whether vetting is the appropriate measure to strengthen judicial independence and impartiality of the judiciary and the prosecution service. Partners in the international community should stand ready to support this process if it is adopted, and to ensure it is robust, fair, and does not result in delays that would impede vital access to justice. In closing, I want to recognize the individuals who I met in every part of the system and in civil society who are sincerely working in good faith to provide justice and serve their country. I commend your efforts, and I stand ready to offer my assistance and support. And I encourage all others in Montenegro and the broader international community to do the same. Thank you.